Donald Trump thought the Supreme Court would save him. Instead, they drew a brutal line, and his entire legal defense just fell off a cliff. Tonight, we're breaking down how Trump's so-called immunity actually opens the door to criminal charges, exposes his private scheming, and could trigger the biggest courtroom meltdown of his political life. This ruling slices his power in half, shoves his election plot into the spotlight, and turns every official act, excuse into a ticking time bomb. If you think this was a win for Trump, wait until you see where his defense begins to collapse.
We have word that the Supreme Court has issued a ruling on the extent of presidential immunity from criminal prosecution for conduct alleged to involve official acts during the tenure of President Trump. This is the big one we've been waiting for. It's consequential. It's really interesting that the Supreme Court, in 248 years of our history, has never actually ruled on this. So it is big and sweeping, and I have our political panel looking over this right now. Andy McCarthy, Chief Justice John Roberts has the writing on this. He's got the pen. Is that significant?
Let's be really clear about what just happened, because the spin machine is already working overtime. The Supreme Court finally ruled on presidential immunity in the Trump case, and a lot of people heard one headline: Trump gets immunity for official acts, and assumed that means he's now untouchable. That's not what this ruling does. In fact, once you strip away the legal jargon and the talking points, what the court handed Trump is a complicated, risky, and potentially devastating mess for his legal defense. For the first time in American history, the Supreme Court laid out a framework for when a president can and can't be criminally prosecuted for things done in office. They didn't say presidents can never be charged. They didn't say anything done while in office is protected. They drew a line. On one side of that line is genuine presidential duty, using constitutional powers, running the government, doing the job voters hired you to do. On the other side is personal conduct, using the office like a private shield, a campaign tool, or a blunt weapon to hang on to power. And for that second category, the court said very plainly, zero immunity.
Sure. Sorry to cut you off. We're going back to Lydia. We have a ruling on immunity. Lydia, what do you got?
Yeah, Ash, this is the big one we've had all eyes on right now. We're getting this just in. Former President Donald Trump from the Supreme Court of the United States does have immunity, and it appears that the decision is limited to his official acts. Remember, a big question after the lower courts in the District of Columbia decided that the former president had no immunity across the board.
The justices divided presidential actions into three categories. First, core constitutional powers. Things only a president can do: issuing pardons, commanding the military, negotiating treaties. For those, the court said there's absolute immunity. You can't charge a president later just because a future administration doesn't like how those powers were used. That's the strongest protection. And honestly, that part isn't controversial. You don't want presidents paralyzed by fear that every policy decision they make will turn into a criminal indictment 10 years later. Second, there are other official acts: firing executive branch officials, delivering speeches as president, signing bills, setting policy, working with Congress. Those are part of the job, but they're not spelled out as core constitutional powers. For that middle bucket, the court gave presidents presumptive immunity. That means prosecutors have an uphill battle. They have to show why charging a president for those acts doesn't threaten the independence of the office. It's not automatic immunity, but it's a big layer of protection. And then comes the third category: unofficial or personal acts. This is the one sentence in the ruling Trump really doesn't want people to pay attention to. For unofficial acts, the court says a president has no immunity, none. If a president does something for personal reasons, to protect themselves, to help their campaign, to attack private enemies, or to cling to power after losing an election, they stand in front of the law like any other citizen. That's the heart of this decision. That's where Trump's legal defense begins to crumble. Because now, everything Trump is accused of doing in his efforts to overturn the 2020 election has to be sorted into one of those buckets. Was it a core constitutional power, Was it some sort of official act? Or was it personal conduct aimed at keeping Trump in office after the voters said no? That's not an abstract debate. That's going to be a series of ugly, fact-heavy hearings in courtrooms all over the country where judges examine the things Trump actually did and ask, was this for the country or was this for Trump? Let's start with one of the best-known pieces of evidence, the call to Georgia's Secretary of State. Trump didn't initiate some standard legal review. He called a state election official from his own party and asked him to find votes, just enough to flip the outcome. That's not how federal election oversight normally works. That's not a routine presidential duty. That sounds like a losing candidate trying to change a result that didn't go his way. Under the Supreme Court's framework, that call now gets put under a microscope. Trump's lawyers will say he was concerned about fraud, that he believed the numbers were wrong, that he was defending election integrity. Prosecutors will say he was pressuring a state official to alter the result for his personal benefit. The audio exists. The transcript exists. Judges will hear the tone, the words, the implied threats. And when you look at that through the lens the court just created, it's very hard to see how that qualifies as an official act deserving immunity. Now think about the fake electors scheme. Trump allies in multiple states organized alternative slates of electors to submit to Congress, even though those states had already certified results showing Trump lost. There's no constitutional duty that says if you don't like the outcome, invent a second set of electors and hope it throws the process into chaos. That isn't the president carrying out the law. That's a political end run around the law. Under this ruling, every step of that scheme gets questioned. Who directed it? What was said in emails and meetings? Were they acting under the color of presidential authority or as campaign operatives? Did Trump use the powers of the office or just his influence as a candidate desperate to stay in office? The more this looks like a coordinated plan to overturn the people's choice, the easier it is for a judge to say, this belongs in the personal category. And that means no immunity at all. Then there's the pressure campaign on Mike Pence. Trump's own vice president had a limited ceremonial role on January 6th. Open envelopes, count the votes, announce the result. Every serious constitutional scholar, every credible lawyer around them knew Pence didn't have the legal power to unilaterally discard states' certified results. Yet Trump repeatedly pushed him to reject or delay the count. That wasn't the president carefully fulfilling a constitutional obligation. That was a man trying to rewrite the rules at the last moment. Again, under the new framework, this becomes a factual inquiry. Was Trump truly acting in an official capacity, making a legal judgment about the electoral process? Or was he exerting personal pressure on Pence to change an outcome he didn't like? The court has told lower judges, answer that question based on evidence. If it's personal, there is no shield. And, of course, we come to January 6th itself. Trump spent weeks telling his supporters the election was stolen, despite courts and his own officials saying otherwise. On that day, he spoke to a crowd that had been fed lies about a rigged election, and he targeted their anger at Congress as it carried out the peaceful transfer of power. This wasn't a policy speech about tax rates or diplomacy. It was a last-ditch effort to stop certification. Is that protected official speech, or is that rally conduct? Part of a campaign-style effort to hold on to the presidency? Under this ruling, that's not a rhetorical question anymore. It's a legal one. Prosecutors will walk in with the speeches, the tweets, the testimony from insiders. They'll argue that Trump crossed the line from president to candidate, from public duty to personal ambition. If a judge agrees that those actions primarily served Trump's personal interest in staying in power, then immunity vanishes and those acts can be charged. This is why the celebration in Trump world is so misplaced. Yes, he got language he can quote at rallies about broad immunity for official acts. Yes, he'll use that line to claim he's being persecuted whenever a prosecutor mentions his name. But every time his lawyers walk into court, they have to do the hard part. Stand in front of a judge and say with a straight face that these highly self-serving actions were the legitimate execution of presidential duties. And the more they do that, the more the facts come out. To claim these acts were official, they have to open the books on who was in the room, what memos were written, what advice was given, what Trump knew, and when he knew it. That means witnesses. That means documents. That means evidence. The very process of arguing for immunity forces Trump's conduct into the open. This ruling also lands very differently across Trump's various cases. In the federal election interference case, it looms large. Prosecutors now have to identify which alleged acts can be charged and which might be insulated as official. But remember, many of the most explosive pieces of conduct, the pressure on states, the fake electors, the pressure on Pence, look far more like personal maneuvering than any recognizable presidential duty. In Georgia, the same logic applies. State prosecutors are focused on Trump's direct efforts to change that state's results. The calls, the pressure, the fake electors, those aren't core constitutional powers. Those aren't normal presidential tasks. They're targeted moves in one state where he lost. It's difficult to dress that up as neutral governance. On the other hand, in the New York hush money case, this ruling hardly gives Trump anything. Paying an adult film actress to keep quiet about alleged affairs before an election is about as personal as it gets. That's not an official act of the presidency. That's not a core power or a policy decision. That case was always going to be about private conduct, and the court's framework just underlines that reality. The bigger picture here is about what kind of country we want to live in. Are we going to accept a system where the president can use the full weight of the office to attack elections, intimidate officials, and cling to power, then shrug and say, well, it was an official act, so there's nothing anyone can do? Or are we going to insist that public power is supposed to be used for public purposes, and when it's abused for private gain, there are consequences? The Supreme Court, even with all its flaws and all its conservative justices, stopped short of declaring the presidency a monarchy. They gave the office strong protections, maybe stronger than some people would like. But they also said something incredibly important. There is a line. When you step over it and act for yourself instead of the country, the cloak of immunity falls away. For a lot of Americans, that's the core issue. This isn't just about Trump's fate in court. It's about whether the rule of law still has any meaning when it reaches the very top. Ordinary people face consequences for breaking the law, sometimes for far less serious conduct than trying to overturn an election. If the most powerful person in the country can treat the law as a suggestion and never be held to account, everything we say about equality under the law becomes hollow. That's why this ruling, despite all the complexity and all the delays it may cause, actually exposes the weakness in Trump's legal position. His defense doesn't rest on proving he's innocent. It rests on redefining his most self-serving actions as official acts, so he can duck accountability altogether. It's not a moral defense, it's a status defense. I did it as president, so you're not allowed to touch me. The court just refused to bless that argument outright. It handed the question back to trial judges and said, you have to look at the facts. That's not the sweeping victory Trump wants people to believe it is. That's a homework assignment for the justice system. And the assignment is to decide piece by piece whether Trump was acting as a guardian of the Constitution or as a man desperate to stay in office at any cost. And here's the truth. Over and over, the facts we already know point in the same direction. He was told there was no widespread fraud. He lost case after case in court. His own officials, his own appointees, told him the results were legitimate. He still pushed lies, still leaned on state officials, still tried to bend the system to his will. Those aren't the actions of someone faithfully executing the laws of the United States. They're the actions of someone trying to escape the consequences of losing an election. So when you hear Trump say the Supreme Court gave him immunity, remember what the ruling actually says. It gives him protection for the parts of the job that really are about serving the country. It does not give him a blank check to do whatever he wants, whenever he wants, without consequences. It does not erase criminal exposure for personal schemes to hold on to power. In some ways, it sharpens that exposure. We're heading into a period where these questions will move from legal theory to courtroom reality. There will be long hearings where lawyers argue over what counts as official. There will be appeals. There will be procedural fights. It will be messy. It will be slow. But through all that noise, the core issue doesn't change. Was Donald Trump using the power of the presidency to uphold the law and the Constitution? Or was he using it to cling to power after voters said his time was up? If the answer is the second, and the evidence already points there, then this ruling doesn't save him. It just sets the stage for judges to say, on the record, that what he did was personal, not official, and therefore not immune. That's when the real trials start. That's when juries get to decide whether that personal conduct was criminal. In a healthy democracy, that's how it should be. Presidents should have room to do the job without fear of endless political prosecutions. But they should never have the power to place themselves permanently above the law. The Supreme Court, despite all its caution and all its deference to the office, did not go that far for Trump. And for a man who has built his entire identity around never facing consequences, that's not a win. That's the beginning of a reckoning.